All right, Tim Blankenship here, Divorce661 Daily Perspective episode 17 for this Wednesday, October 25th. Busy day as always. We're going to talk about new cases. We're going to talk about um, waiting to file if you're not quite amicable. We're going to talk about when you should file a response. Got a lot of stuff today. Going to talk about a Riverside case that we filed on. Going to talk about Craigslist paralegals. Again, talking about responses. We're going to talk about status conference hearings and why you may get notice to hearing and why you need to pay attention to that. About trying to file your own judgment and timelines when it comes to divorce. A lot of things happening today, so I'll probably keep it brief. I'm going to try, but there's a lot of stuff to go over here. So we do these videos every day. I say we, it's me and me in my hat, and I do these videos every day to tell you what my clients are having issues with, what cases I'm handling, what documents people are having problems with, court issues, timelines, and all that good stuff. So let's get into it. All right, what I do today. So aside from doing a lot, we had two new cases that we filed with LA County. Both these clients happen to be from Lancaster. If you haven't heard me comment before, anywhere in LA County, I don't care where you're at, Pomona, how far east? Pomona, all the way south to Long Beach, north to Lancaster, and anywhere in between. I'm going to file you at the central courthouse. It doesn't matter. You're not going to court. So anyways, just two clients from Lancaster today for that court. Oh, and we had another case that we filed this morning. I tell you, I'm usually in here. This morning I was up at 3:45. Right now it's going on close to 5. But I filed a case at 5:54 this morning, and we had it filed right away at 8 a.m. with LA County's eFile, which is, I'm always talking about being amazing. On top of that, I also had 3 LA County divorce cases approved. So judgments we had submitted a few days ago, they finally got approved. And it was interesting to note about this is one took 1 day to get approved by the court, one took 2 days, and another one took 30 days to get approved. And they weren't any different or difficult. It's a standard divorce package. Normally they're a few days, just a few days for approval, but this one was like 32 days for approval. And same person, they have a bunch of different courtrooms and departments and clerks, and the people that are processing these, I don't know, sometimes maybe they just get buried or they fall behind or what. We're happy to just handle the case that's right in front of them and forget about what the ones that are in the past. I don't know. But yeah, 30 days. And there was nothing wrong with the case. It wasn't rejected or anything like that. All right. So what else do we have here? So I have a note here, waiting to file until you are more amicable, had a consult or they weren't in agreement. So I had someone once in a while when people will call, and I can tell on the phone through the consultation that they're not exactly on the same page or amicable or cooperative, I'll tell them don't file, don't exacerbate the problem by now filing for divorce when you guys aren't in agreement, because all you're going to do is stoke fears, and people are going to end up going out and getting an attorney because they're afraid of what's going to happen and they're being served and all this. So I'm generally telling people, what's the rush? Wouldn't it make more sense to wait until you are more amicable or you've reached an agreement, then file and go through the process very smoothly, as opposed to, and I hear this is what people say, well, I want to start the clock on the 6 months, and I totally get that. But what the point is, because you want to finalize it faster, but what's the point of exacerbating the problem and then it takes a year because you end up getting attorneys and having to go to court and you guys are all upset with each other, as opposed to, I think they waited 3 months. And they called me back and said, hey, things are better now. We figured everything out. We kind of got past all of our upset with each other. And guess what? We did their paperwork. We filed it today. This is the case that got filed this morning. And they're going to be sending me their settlement agreement. It will probably be done within the week. So I think that's a much better way to go. So that's my advice. If you are not really there on an agreement, just hold off. I'll be here when you're ready. All right. Next, we have a respondent who filed a response and were amicable and judgment was submitted, then rejected, and the petitioner no longer communicating. So this was an interesting call. So the petitioner filed, the respondent filed a response. They did their financial disclosures. They signed a settlement agreement and notarized it. And when they turned in their judgment package, it got rejected. And it got rejected because of a procedural document being missing. And this is when you do your disclosures, you have to sign this form called Declaration Regarding Service of Declaration of Disclosures, the FL 141. and that didn't get signed by the petitioner, so the judgment got rejected because it's a mandatory form. The call was about, Tim, how can I submit my judgment and finalize it without her signing that, because she's no longer communicating or responding to texts. And that is a big issue, because even though you have a signed settlement agreement, the court will never accept it without that all the procedural forms being signed by both parties. So one piece of advice is just wait, and hopefully she'll eventually sign it. If not, it's as if that settlement agreement never even existed, and you're going to have to go to trial. You're going to have to set the case for trial, depending on what county you're in. If it's LA County, you do a request for a trial setting and get into court. And even though you have a full agreement, that's the route that's going to go, because if there's a judgment rejection, and especially if it's for a procedural document that was missed or forgotten or not signed or an error, it's as if there's no agreement at all. Next subject, Riverside eFile. So Riverside now is allowing for eFile, and they're just not that fast. I mean, they're okay, but here is the predicament. Like if we're going to start a new case for you in Riverside, now we can eFile. Before, it was like San Bernardino, where we had to mail it in. It would take 3 weeks to get back. It's terrible. At least now we can eFile with Riverside, and this response, it wasn't bad. It took 3 days to get it filed. But here was the issue. It's one of these cases where, and I don't take these on too often, where the petitioner had filed, the wife had filed, and he was served, and a couple of months had went by. He asked about, are we going to come to an agreement? I was talking about this yesterday. And she said, no, I'm filing the default. And I was talking about why you don't want to do that. And I said, it's probably going to be safer just to get the default in. It's going to save you both the trouble, because someone's giving her wrong instructions to try and do this default when you have kids in the house and all this stuff. So we filed the petition, we e-filed the response, and we got a confirmation that it was received. And then the next day I got a confirmation that it was accepted, but it still wasn't filed. And all this time, the wife could have filed the default. She could have walked into court, gotten the clerk, and they could have snapped it, and that would have taken effect before the response took effect, and then the response would have got rejected. But the response did get accepted. We did get confirmation. We got filed copies today. So 3 days, just keep that in mind. Much better than 3 weeks. Okay, so here's my note on Craigslist paralegals. Should you use Craigslist to find a divorce paralegal? When things went wrong, so what happened was, I had some clients retain me who had said, they found this paralegal on Craigslist, and that they paid them, and they did their initial paperwork, took their money, and then ghosted them. Totally gone. Can't get a hold of them. They don't have an office. All it is a phone number, probably a Google Voice number, not even to your cell phone. And when I saw when they sent me their paperwork, and I saw who did it, I couldn't believe that this guy was still around. I don't know if everyone knows about him, but maybe it's because I handle so many clients that somehow get scammed by him. When I saw the name, I haven't heard the name in like 5 years, and here he is right back at it. And then the reviews, like on Yelp and all this, I mean, he gets lit up. I don't think he cares, because he's not promoting himself online. He's doing it through Craigslist, because he has to kind of be in the dark underbelly of the world to get clients, because if you try and find them online, you would never hire him, because it says scam. Someone posted in one of the comments that he'd been arrested for drugs, and I Googled it, and sure enough, there it is. It was like on the crime wire for LA County. So people, if you're going to go on Craigslist, I don't recommend it, but if you find someone, I guess they don't even have to give you a real name on Craigslist, so you wouldn't even know who to search for. But all the comments said, I found this person to do our paperwork, and everything seemed good. And as soon as we paid him, he went away. And so that's your warning. Don't use a paralegal on Craigslist. And that also reminds me, there's people that do what I do that, and I guess it's fine. They don't have a website. They have no information. I usually find this out when someone will hire me after hiring another paralegal service or LDA, and they can't finalize their divorce. The paperwork's all screwed up or whatnot. And so I'll Google the name, and there's no website. There's like an Instagram account, maybe a Facebook page, not even a LinkedIn sometimes. So these people exist solely either by word of mouth or just through social media. They have no website presence. They have no addresses. I don't get it. I don't know how you can have a legitimate business going that way. And as it appears, they're not actually doing the job that they're being hired for. All right, next subject. Filing a response. I talk a lot about how it's not needed in amicable cases, but there are times when you would want to file it. If you're not in agreement or you're not working with me, where I'm assisting both of you, you'll probably want to file your response. Kind of going back to the client I was just talking about, where it's not 100%, amicable or on the same page, and the spouse isn't really communicating with them, because on the summons it does say, if you don't file a response, your spouse gets everything, which isn't the case, but you know it's not wrong to file a response. I only tell my clients not to do it because I'm in control of both of you, not in a negative way. I'm just saying I'm working with both of you. I'm not going to default. We're not going that route. We're doing this amicably. Filing the response triggers another $435 fee. So why pay that? But if things are not exactly, absolutely going well, then file the response within the 30 days. And that's kind of why, again, why we did this for this gentleman in Riverside yesterday. Wanted to get that response filed. Next subject, status conference hearings. If your case is not moving forward within a particular time frames, and it's different with all the courts, but there's a pattern here. The courts will send out a notice of status conference saying, and they're basically calling you into court. And most of the time it can be through a telephonic hearing, a remote hearing. You don't have to actually go to court. I don't think they want you there anymore anyways, but you don't have to worry about them. They're just calling you into court to say, hey, it's been 3 months and the proof of service hasn't been filed. That's usually the first trigger. And so we just want to make sure you know what you're doing, what's going on, and what's next, and so forth. Where I noticed, so I had two clients get those today because they're just being a little slow in there and getting me the information in the process, but we did file. I think this one was in July. So, but what was interesting is it happened twice last week where they got notices. And I thought, usually the court will give you a solid 45 days notice, but when I logged into the case summary, I can see when that notice was generated by the court. And from that date to the date of this hearing, it was like 7 court days. So they're giving you like a week. So they stick it in the mail on, the 20th, and your hearing's on the 31st. And so, I mean, you basically have no time to react. They are remote, so it's not a big deal, but there's ways of avoiding those. If you're my client and you get a notice because it hasn't moved forward because you haven't worked on your agreements or whatever, and that's not a problem for me. It's not really a problem for the court. They just want to know what's going on and why it's not moving forward. So just keep an eye out for hearings. Like, I don't represent you. I'm the neutral third party. You guys are self-represented. So any notices that go out directly from the court that's not filed by me go directly to you. The documents I eFile for you come directly back to me, but anything self-generated by the court is going to go to you. So always, if you get something from court, just upload it to the My Case portal so I can take a look at and address whatever it needs to be addressed so we can keep you from having to go to court. Okay, the next subject is sometimes people want to get involved in the process that I'm putting them through, and they want to speed up the process. And normally this is in regards to filing the judgment with the court. So today we had finalized some paperwork for people in Contra Costa. I got yelled at on YouTube for saying Contra Costa, and I get it. There's no A in it. So Contra Costa, and they don't have eFile. So they're saying, well, Tim, now that the paperwork's done, why should we mail it to you only for you to mail it to the court? Why don't we either them mail it directly to the court, or they're close to the court, they want to walk it in? And I get asked that once a month. And I plead with people to please not do that because it gets rejected every time. I know you want it to get approved faster, but it doesn't help if you turn it in the paperwork in incorrectly. And it has to be done a certain way. I always put it under my cover letter so they know it's been professionally done. So they're going to give it the due diligence of reviewing it properly, because the courts are so busy, 3 to 6 months for processing judgments. They're looking for a reason to reject it and stick it back in the envelope and mail it back to you. Don't 2-hole punch your originals, rejected. Don't have original and 2 copies or whatever the requirement is for that particular court, rejected. Don't have the envelopes with enough postage, rejected. I mean, they're looking for any reason. It's, the paperwork isn't put together correctly. You don't have the judgment package in the right order. So I would plead with you, it's not going to save you time. Turn it in. It gets rejected. And then you say, you know what, Tim, you're right. mail it to me, and now a month or two has gone by, and then I'm going to prep it and then submit it. Please just let me, you paid me for it. It's part of the service. Please let me handle that final step. Plus, I make mistakes too. I'm not perfect. When I do it online and I prepare your paperwork and you sign it, when it comes back into me, I get to get eyes on it one more time, one more final review of going through it instead of looking at it on my screen, actually looking at it down on the paperwork, reviewing it by hand, making sure that there's no more corrections to be made procedurally, not changing any of the terms, but just making sure the check boxes are right. You didn't check the wrong petitioner or respondent one more time. And I'll catch something every once in a while. And I'm saying, I'm sure glad I got this to look at one more time before returning to court. And then I know I'm setting up a package that's not going to get rejected by the court. Okay. And then the next question, or I'm sorry, the next thing that came up that I want to talk about is the process of what happens when you turn your judgment into the court. I've told you that when you file your petition or you file some of your preliminary disclosures and so forth, maybe your income and expense or whatever you're filing, anything before the judgment is just accepted by the court and stamped. It's not reviewed. So when you turn in your judgment, and when you file those, you get a stamp. You can walk into the court if that's what you did, or you e-file it, and you get the turnaround is usually a couple days or whatever, and it gets stamped. With the judgment, that's not the way it works with the court. When you turn in, so this was in Contra Costa, the same people actually that wanted to walk it in and say, hey, well, I guess if I turn it in, I'll give it to the clerk and they'll approve it right there on the spot. Absolutely incorrect. It goes to a judgment clerk, goes to a whole nother department, and it's just going to get put in a pile, and it's going to go through the normal channels. They won't even give you a receipt. So like when I mail documents to courts where we have to mail the documents still to, I always do it with a USPS priority mail because it comes with free tracking. It's like less than $10. And it's like, it's 400 pieces of paper that I have to mail up there, and it's covered by that. So I can, that's my receipt of it being received, because the court isn't going to acknowledge it in any way. But once it's in, it's just going to sit there until it's reviewed and approved. And it's as long as it takes. Again, Ventura, 6 months, Contra Costa, 3 to 4 months, Riverside, 2 to 3 months, Orange County, we got one back in a month, and sometimes it's 2 months. So it just, we file enough divorce cases and judgments to know when we're going to get those back. Now, LA County, we are getting, you get, because we can e-file the judgment package, everything. We get an immediate email notification of it being received, and some of the documents auto approved, meaning they must have some algorithm or AI that's able to review the form, and we get the approval on everything but the judgment and the request and the notice of entry of judgment, because that has to be eyes on, reviewed by a human being. And then even those we're getting back in 2 days. So as I say, I wish you all lived in LA County, but I do work with all clients throughout California. It just takes a little bit longer to get those approved. We're still within that 6-month window, because if you're starting with us from scratch, because we're getting everything done and in that 31st day, or within 2 months at least, in line for review and approval. So we're trying to not have you go beyond that 6 months. I hope you enjoyed today's Daily Perspective, episode 17, and we'll talk to you tomorrow.